You just finished a long shift, and you're sitting at the kitchen table, scrolling through your phone at midnight. You've been doing a side hustle for a few months, maybe fixing cars in your driveway, selling handmade furniture, or running landscaping jobs on the weekends. You're making decent money, but suddenly, a terrifying thought hits you. What happens if something goes wrong? What if a customer sues you? You don't have any official paperwork set up, and you're wondering if you're running a business illegally. Stay with me, because we're going to break down exactly how the law sees your side hustle and what it means for your personal bank account. Let's get one thing straight right away. You aren't going to jail just for making money without an LLC. An LLC, which stands for Limited Liability Company, is just a specific type of legal wrapper that creates a separation between your business assets and your personal assets. Operating without one isn't a crime. You aren't breaking the law by offering a service or selling a product without that official state paperwork. You are completely allowed to wake up tomorrow, buy a lawnmower, and start cutting grass for cash. The police are going to show up and arrest you for lacking a corporate seal. But even though you aren't breaking the law, you are taking on a massive amount of financial risk. To understand why, we need to talk about how the law views you right now. When you don't have an LLC, the law looks at you and your business as the exact same living, breathing person. There's no line drawn between the two. In the legal world, this is called a sole proprietorship. A sole proprietorship is just a fancy term that means you are the undisputed boss, but you alone carry all the legal and financial burden of the business. If the business gets into trouble, you personally get into trouble. Let's use a really concrete example to paint this picture. Imagine you run a mobile car detailing business out of the back of your pickup truck. You're operating as a sole proprietorship right now, just you and your pressure washer. One afternoon, you're cleaning the interior of a client's vintage sports car. You accidentally knock over your bottle of industrial solvent, and it ruins the custom leather seats. The repair bill is $6,000. The customer is furious, and he decides to sue you for the damages. If you had an LLC, the customer would have to sue the business. But because you don't have one, he sues you personally. He sues John Smith, the individual, not John Smith Auto Detailing. Because there's no legal separation, a judge can allow the angry customer to go after your personal savings account to get his $6,000. The customer's lawyer can demand that you empty your personal checking account to pay the bill, but it actually gets much scarier than just your bank account. If $6,000 is too much for you to pay in cash, the court can force you to sell your personal property to cover the debt. In law, this is known as piercing the corporate veil, but since you don't have a corporate veil, the door to your personal life is wide open. The judge could allow a lien to be placed on your house. A lien is just a legal claim that keeps you from selling your property without paying off your debt first. They could even move to garnish your wages from your regular day job. Garnishing your wages means the court orders your employer to send a portion of your weekly paycheck directly to the angry customer until the debt is completely paid off. Now, let's take this scenario one step further to show you exactly why people bother setting up LLCs in the first place. Imagine instead of just ruining a leather seat, you accidentally left your shop vac running in the driveway. A child trips over the cord, falls onto the concrete, and breaks their arm. The parents sue you for the massive hospital bills and their pain and suffering. When you're a sole proprietor, your personal life is completely exposed to pay for this tragedy. This means your family could be forced to bankruptcy. A bankruptcy is a legal process where you declare you cannot pay your debts, and you ask a federal court to help you wipe the slate clean or reorganize your payments. Bankruptcy ruins your credit for years and stays on your public record for a decade. When you form an LLC, you create a liability shield. A liability shield is exactly what it sounds like, a barrier that blocks business disasters from reaching your personal life. If you had an LLC set up and that exact same accident with the shop vac happened, the lawsuit would be forced to stay inside the business. The angry parents could sue the LLC, and they could take every single tool inside your truck. They could take the business bank account, the pressure washer, and all the cleaning chemicals. But they legally cannot touch your personal paycheck from your day job. They can't touch your personal savings, your kid's college fund, or the equity in your house. That invisible wall stands firm, and it protects the things you've worked your entire life to build. Now you might be asking yourself how you actually get one of these liability shields. To set up an LLC, you have to file a specific document with your state government. This document is usually called the Articles of Organization. The Articles of Organization is just a simple form where you tell the state the name of your business, where it's physically located, and who the owners are. You usually pay a filing fee to the state to process this paperwork. Keep in mind, this filing fee varies wildly depending on where you live. In some states, you can set up an LLC for $50. In other states like California, the initial fee and the ongoing annual fees can cost you hundreds of dollars every single year just to keep the doors open. Another thing to remember is that states have different rules for how you maintain this shield once you get it. For example, many states require you to publish a notice in a local newspaper announcing that you formed your LLC. This is called publishing a statement, and again, the rules vary. Some states are very strict and charge you hefty fines if you don't get it done. You also have to keep your personal money completely separate from your business money once you have an LLC. If you deposit your customers' cash directly into your personal grocery fund, you are commingling funds. Commingling funds is a big mistake where you mix your personal cash with your business cash. If you do that, a judge can easily tear down your liability shield and come after your personal house anyway, making all that expensive state paperwork completely useless. So when exactly is the right time in the life of your business to finally get this paperwork handled? This isn't legal advice for your specific situation because everyone's risks and state laws are different. But generally speaking, a sole proprietorship is fine when you are just testing the waters. If you're just doing odd jobs for your neighbors, making 20 bucks here and there, and you have very little risk of hurting someone or destroying expensive property, the risk might be manageable. You can operate as a sole proprietorship while you figure out if the business is actually going to work. However, the moment you start signing contracts with bigger clients, the moment you start buying expensive inventory, or the moment your personal assets become significant, you should strongly consider making a change. You should definitely look into getting an LLC when you start buying vehicles or equipment in the business name, when you hire employees, or when you rent out a physical workspace like a commercial garage or a storefront. Anytime the scale of what you're doing increases, the potential for a disaster increases, and that liability shield becomes your absolute best friend. Don't forget about the tax side of things either. How you are taxed changes based on how your business is legally set up. When you're a sole proprietor, the federal government taxes you through something called a Schedule C. A Schedule C is just a specific tax form where you list your business income and your business expenses, and the profit gets added directly to your personal income tax return. You pay regular income tax on that money, and you also pay something called self-employment tax. Self-employment tax is the mandatory contribution you make to the federal government for Medicare and Social Security, since you don't have an employer withholding those taxes from a paycheck for you. Some people form an LLC specifically because they want the option to be taxed as a different entity, which can sometimes lower that self-employment tax burden. An LLC gives you choices on how the IRS views you, which a sole proprietorship doesn't offer. But remember, tax laws are just as tricky and variable as liability laws, and they change based on national policy and your local state rules. You absolutely need to talk to a certified public accountant to see if your business has reached the level where changing your structure makes financial sense. At the end of the day, running a business without an LLC is incredibly common, and it's completely legal. You aren't hiding from the police, and you aren't committing white-collar crimes just by fixing lawnmowers in your garage without a state stamp of approval. The police and the courts don't care about your hustle, they only get involved when things go wrong. The lack of an LLC simply means you're choosing to roll the dice with your personal life. You are choosing to bet your personal savings, your personal credit score, and your personal property on the hope that nothing disastrous ever happens on the job. The law gives you the freedom to operate this way if you want to. The trade-off for that freedom is risk. As long as you understand that your personal bank account is totally on the line every time you interact with a customer or step foot on a job site, you can make an informed decision about your future. Business owners make decisions based on facts, not fear. Now you know the facts. You understand the difference between being a sole proprietorship and having a liability shield, and you recognize the exact risks you face at this very moment. If you've been lying awake worrying about this tonight, you can finally stop stressing about going to jail over your side hustle. You can rest easy knowing you aren't a criminal. But tomorrow morning, it's time to look at your situation clearly, evaluate the actual risks of your daily operations, and decide if it's time to call a local attorney to get your business protected. A local lawyer can sit down with you, look at your specific state laws, and tell you exactly how much it will cost to build that legal wall around your family's financial future. What side hustle or small business are you building right now? And what's the biggest headache you've run into so far? Let me know down in the comments. If this breakdown helped clear up your midnight anxiety, pass it along to a friend who's also out there hustling to make a living. And subscribe to Scribble Law so you'll always have a guide the next time the legal system throws a curveball at your hard work.